Welcome to the deep dive. We talk a lot about reasonable adjustments at work, but what happens when a really serious health crisis, something like PTSD, collides with well, the cold procedural machine of the UK legal system?
Exactly. We're going to look at what happens when that duty to accommodate a disability just, completely fails.
And we're following it all the way from that initial conflict in the workplace, right up through the employment tribunal.
That's right. And for this deep dive, we've pulled together a huge amount of material. We have everything from internal grievance forms and occupational health records.
To the formal legal claims.
Yep. And crucially, expert legal commentary that really analyzes the hurdles that people face when they have to represent themselves in court.
So our mission here is, I think, pretty clear. We're trying to extract the key insights on these systemic barriers that can just completely undermine the whole idea of a fair hearing.
Especially when someone's health, their disability, means they have to rely on the system showing some procedural kindness.
Okay, so let's get into it. Let's start right at that moment the workplace just became unbearable.
So we're starting with the details from an internal complaint form, and it's against a team leader in a government department.
And the conflict was about training.
Essentially, yeah. A difference in views on some required training sessions. But the incident itself, it was just devastating. It happened on a Friday afternoon over an online meeting.
What makes this so critical from what I've seen is the environment and the actual language that was used.
Oh, absolutely. The person involved was, and this is a quote, publicly and disrespectfully called a liar and told flat out they were wrong.
And then ordered to apologize.
Ordered, the manager said they had to apologize to him.
And the public part of this is just, it's key to understanding the damage, isn't it?
It is. Because the team leader was in an open plan office, this whole denigration happened in the full hearing of all DWP colleagues.
Wow.
The complainant described feeling like they were treated like some kind of village idiot.
And here's the context that shifts this from just a really bad day at work to a genuine health crisis. The person being attacked was already working from home, and they were actively being treated for post-traumatic stress disorder.
And that condition, it's important to note, developed after they were left doing lone work with vulnerable claimants on suicide calls. So this isn't just burnout.
No, this is a serious, documented condition that should have had protections around it.
Absolutely. And the complaint shows an even deeper breach of trust. The claimant alleges the team leaders shared their personal health issues with colleagues.
Even after being asked not to.
Exactly. Showing, in their words, zero consideration for mental health impact. The whole conflict lasted 28 minutes, and the request for a third party to mediate was just ignored.
So they were trapped.
They had to invent an excuse saying they needed the toilet just to get away from the confrontation.
Okay, wait, I have to stop you there. So this wasn't just them saying they felt anxious. What did the actual medical documents say they needed?
The documents were very concrete. They confirmed diagnoses of PTSD, stress, and anxiety. And back in May 2022, occupational health had been incredibly clear.
What were their recommendations?
They issued strong recommendations for temporary adjustments, things like a reduced caseload, avoiding calls with suicidal customers, and no office-based work until specialist equipment was in place.
And importantly, management was actually mandated to do certain things, right? Like a stress risk assessment.
Mandated. A stress risk assessment and a wellness recovery action plan, or a WRAP.
So mandatory actions.
Precisely. But the evidence suggests these internal protections, they just never happened or they were ignored. And that's the failure that pushes this person into the legal system.
And that failure to adjust is the whole reason they end up in court. So in the formal claim, they identify their PTSD not just as a workplace issue, but as a disability that would affect them in the legal process itself.
That is such a crucial distinction to make. The reasonable adjustments they needed went beyond just their job duties.
Because the disability itself creates new problems in a legal setting.
Right. Because of difficulty focusing, memory issues, and physical problems, like not being able to sit or stand for long, they needed procedural adjustments from the court. More time for paperwork, for example.
But getting those adjustments, even internally, was just a nightmare. We've seen a transcript snippet where the manager had actually reported the claimant to HR.
Get this. For not attending a reasonable adjustments meeting.
It's just absurd.
It's completely Kafkaesque. The claimant had already been to 3 of these meetings, and now they were just trying to enforce their right to have a union rep with them for a 4th one.
So while trying to get their rights respected, they're being disciplined for non-attendance.
Exactly. The claimant was standing firm, saying no union rep, no meeting, But the clock is ticking, and they're the one being penalized. It feels less like bad management and more like a systemic trap.
So the court system is supposed to be the safety net here. It's supposed to catch this stuff. Isn't there a legal principle designed to stop this exact kind of thing from happening?
There is, and it's a vital one. It brings us to the legal principle that the duty not to discriminate includes accommodating the behavioral symptoms of an impairment.
Can you tell us a bit more about that? What does the precedent say?
Well, it's pretty established in cases like Chief Constable of South Yorkshire Police v. Jellick. These cases basically confirm that if someone shows frustration, irritability, or has communication issues,
And those things are directly linked to their PTSD or stress.
then those behaviors have to be managed through reasonable adjustment. They can't just be treated as, being difficult or insubordinate. The law gets that the disability can express itself as behavior.
And here's where that principle just completely slams into the reality of what happened in this tribunal.
Yes.
The claimant tries to explain their symptoms during a hearing: dizziness, nausea, circulation problems, just feeling incredibly unwell.
Yeah.
How did the court handle that?
They failed spectacularly to apply that principle. According to the claimant's correction request, the judge's summary reduced all of those severe multiple symptoms to just a headache.
A headache, that's it.
And it gets worse. When the claimant tried to explain how their condition and their medication affected their memory and their focus, the judge actually characterized them as argumentative.
Argumentative. So the very behaviors the law says you have to accommodate were instead used against them to undermine their credibility.
Precisely. It's the exact failure those legal precedents were designed to prevent. Instead of seeing the exhaustion or the difficulty focusing as symptoms that need accommodation, the court treated them as a personality flaw. It just shows this huge gulf between the law on paper and the reality of navigating the system when you're ill.
That experience takes us right into the systemic problems that anyone faces when they have to represent themselves in court. The litigant in person or lip-P.
And the disparity is just staggering. Legal analysts call it the inequality of arms.
What are the numbers?
So the commentary we have notes that roughly a third of all claimants in employment tribunals are unrepresented. They're lip-Ps. Now compare that to the employers. 77% of employers have professional legal representation. Solicitors, barristers. The analysis says this imbalance amplifies inequity.
So if the playing field is already tilted that far, I imagine the loop just becomes a target.
They do. The lawyers on the other side can exploit the fact that the LEAP doesn't know all the procedural rules. They'll try to get the case thrown out right away with strikeout applications, or they'll use something called a deposit order.
What's a deposit order in practical terms?
It's basically a financial chokehold. The tribunal can order the claimant to pay up to £1,000 per allegation just to continue their case.
£1,000.
Yeah, if the tribunal thinks their argument has a little reasonable prospect of success. For someone who's vulnerable, probably out of work, it's designed to force them to just give up.
And in this specific case, the procedural unfairness that was alleged late in the game is it's shocking. It really sounds like a deliberate move to overwhelm them.
It absolutely does. The claimant was asking for a postponement of a hearing, and they noted there hadn't been any formal judicial direction on it for over a year.
And then what happened?
Then, with less than 48 hours notice before the hearing, the employer's side serves this massive new evidence bundle.
How big?
460 pages, along with a costs schedule.
48 hours to get through 460 pages. That's a tsunami of paper for anyone, let alone someone who needs adaptive technology and has documented focus and anxiety issues.
And that was the core of their argument. The claimant said this put them at a serious disadvantage as a disabled litigant in person. It just destroys their ability to participate fairly. They also pointed to a clear legal precedent, arguing the hearing should have been stayed anyway while the main judgment was being appealed.
The complexity is just overwhelming.
It is. And there was also this issue of integrity with the evidence itself, wasn't there?
Yes. The claimant alleged that one of the employer's witnesses actually admitted under oath that her witness statement was drafted entirely by the employer's solicitors.
And the claimant argued that this completely undermines the reliability of the evidence, but the tribunal reportedly did nothing about it. It just suggests that even when you point out these huge integrity issues, you still struggle to get any kind of redress.
So, the tribunal is a minefield. That brings us to the next step. The Employment Appeal Tribunal, or EAT. If you manage to survive and want to appeal, you can't just say, I disagree, can you?
Not at all. You have to identify an arguable error of law in that original decision. And if you're in LIPI who needs reasonable adjustments in the EE process itself, the burden of proof is completely on you.
And what does that burden actually look like?
It's intensely procedural. You have to file a whole formal application. You detail your disability, explain exactly how it causes you problems in the EE process, state the specific adjustment you need, and provide medical evidence to back it all up.
So you have to fight to prove your need for accommodation, all while you're dealing with the very effects of that condition.
Exactly. The system is just set up to assume procedural perfection.
And we can see how fast things can go wrong, even with representation. In that Drysdale v. Department of Transport case, it really shows the limits of how much a judge will step in.
Right. In Drysdale, the claimant's representative, who was his wife, suddenly withdrew the claim during the hearing. She was apparently really stressed and disappointed. The ET upheld the dismissal.
Why?
They ruled the tribunal didn't have to check if she had the authority to do that unless there was, open conflict right there in the room. Even though the claimant later said she didn't have his permission, he didn't object at that exact moment.
It just highlights how cautious judges are. They don't want to cross that line from assisting to advocating, even if a terrible decision is being made under pressure.
And this fear of the system, this expectation of perfection, it drives a behavior we see everywhere, not just with litigants, but in the legal profession itself, self-accommodation.
What does that mean exactly?
The Legally Disabled Report defines it as where people actively hide their impairment or they make their own adjustments in secret because they're afraid of discrimination.
So, like a lawyer leaving early for physiotherapy.
But making up the time by working through lunch every single day and never telling a soul.
They're basically operating in stealth mode just to meet the standard demands. What did the survey results find?
They're really eye-opening. The report found that 57.2% of solicitors and paralegals surveyed did not disclose their disability to recruitment agencies. This whole culture just rewards concealment and penalizes needing help.
So given all these really deep-seated problems, from workplace bullying to a tribunal system that treats symptoms as bad behavior, what are the actual structural reforms that legal experts are suggesting to level this battlefield?
The recommendations really fall into three key areas, and they're all designed to fix the systemic flaws. First is strengthening judicial case management and training.
Meaning the judge becomes more of an active guide than a passive referee.
Exactly. They need to be trained and empowered to help LIPIs clarify issues and frame their claims correctly. Second is just simplifying the procedures and the forms. The first claim form, the ET1, could be redesigned to be much more user-friendly.
Lowering the barrier to entry for justice.
Right. And third, there's a recognition that this kind of adversarial fight might just be the wrong place for certain issues, like whistleblowing.
So what's the alternative?
Commentators are proposing an independent office of the whistleblower. This body would handle the investigation and protection completely outside of the tribunal system. It would take that crushing burden off the individual who's trying to fight their employer one-on-one.
So what does this all mean for you, the listener? The journey we've just followed, from an employee being publicly called a liar to their fight for basic fairness in a tribunal, it reveals a system where procedural complexity and really a culture of ableism just systematically stack the odds against disabled, unrepresented people.
And while the ideal tribunal is supposed to be easily accessible, the reality is just overwhelming. Outcomes risk turning not on the merits of the case, but on who has the money for lawyers and who can withstand these procedural ambushes.
We saw that the whole point of reasonable adjustments is to level the playing field. But what does equality of arms really mean when a vulnerable person, someone who relies on adaptive technology because of their health, gets ambushed with 460 pages of documents just 48 hours before a hearing? It raises a fundamental question of whether procedural fairness is even possible in a system like this without judges being required to proactively protect the most vulnerable, something for you to mull over.